Good evening and welcome. My name is Rachel Cass, and on behalf of Harvard Bookstore, it's my pleasure to welcome you here to the historic First Parish Church. We're very pleased tonight to have Justice Breyer joined in conversation by David Gergen, Professor of Public Policy here at the Kennedy School and co-director of the Center for Public Leadership. It's now my distinct pleasure to introduce tonight's author. Stephen Breyer began his legal career as a clerk for Justice Arthur Goldberg. After holding a number of important legal positions in Washington, including counsel for the Senate Judiciary Committee, as well as a distinguished academic career here at Harvard Law School, he was appointed by President Clinton to the Supreme Court in 1994, filling the seat of retiring Justice Harry Blackmun. In his years on the court, he has been known for his holistic approach to constitutional interpretation, a philosophy he laid out in his first book, Active Liberty. He is also the author of Making Our Democracy Work, an exploration of the judicial branch's role in maintaining the citizenry's faith in a strong democracy. Justice Breyer's new book, The Court and the World, looks at the role of foreign law and precedent in the decisions of the Supreme Court, acknowledging that the world is more interconnected than it has ever been, in ways technological, financial, environmental, and more. It is a topic that will only become more relevant in the years to come, and we're very pleased to have him here tonight to discuss it with us.
Well, thank you for being here tonight. This is a time, of course, when Americans are having declining faith in many institutions. Politics has been hard hit. Congress has been extremely hard hit. They wonder about the court, and I think your presence here tonight, we'll wait and see, but I will bet you come away reassured. I had the opportunity to hear the justice over at the Kennedy School just a while ago. He had a joint appointment at the Kennedy School along with the law school. Of course, he was here at the law school for many years. And there was an elegance to his thinking and to his speaking, but a commitment that you felt walking away, I feel better about the court and where we're going. So, and you might tell us, I did not, we were just talking, you actually hold what was once called the Massachusetts seat in the court?
Yes, David, thank you, by the way, for the introduction, and thank you for coming. And it's true, you can go back and trace the people who have held the seat before you, and the last one was Harry Blackmun. And Harry Blackmun wrote, he told me the most interesting and truthful thing about this job. Uh-huh. He said, "You will find this an unusual assignment."
In what sense?
I don't think I'll elaborate, but it is, you'll get the picture over a while. It is unusual, and it is very interesting, and it is.
Well, you've said that there's a lot of reading and writing.
Yes, that's what the job is. I mean, I said that Eli should take that in. I said that basically what an appeals court judge does, and an appellate judge, and that's what we're a form of, is you read briefs, and you write opinions. So my life is at the word processor, and there we are. Or it's reading the briefs. So I told him, if you do your homework very well, you will get a job where you can do homework your entire life.
Now, it is also true that when people look at the divisions that get so much attention in the court, and also read some of the more fiery rhetoric, that they have a sense that there's sort of a war going on inside the court, and yet that is not at all the portrait that comes through in books such as Jeffrey Toobin's book about the court called The Nine. It seemed much more collegial, and that you were portrayed as the optimist and the cheerful one on the court.
I mean, let's go back. The court does have a long history. And it's had ups and downs like all institutions. And before Harry Blackmun, there was Fortas and Goldberg and Frankfurter. And you can go back beyond Frankfurter. You can go back to Holmes and Joseph Story. And it was the Massachusetts seat. And I don't usually say that because I feel I'm setting an awfully high expectation in the audience if I start talking about Holmes and Story and Frankfurter and so forth, but that is the seat. Now, I said a few minutes ago to the students, and I want to emphasize it to them, that yes, of course, we have difficult cases, and they do produce conflicts of opinion. So, I mean, that's what the job is. I mean, we take cases where the lower courts have divided on the interpretation of a federal law. That can be a statute passed by Congress, or it could be the Constitution. And that's why we take the case. They're good judges. Why have they reached different opinions? The answer is because it's a difficult question. The law is more or less open. And the reason, said Taft, when Taft was president and then he was Chief Justice of the United States, and he explained it. He said, why are we here? We're not here to correct errors. We rarely do that. Everyone who's brought a case to us has already had a trial, has already had an appeal, and many of them have had 2 or 3 appeals. And there are thousands, there are millions, in fact. And my goodness, how could we do that? Why are we going to get it right if the lower courts got it wrong? But if our job is simply to create a uniform interpretation where different lower courts have reached different conclusions as to the meaning of the same text, that's possible. There are not that many, and that's what we take. Obviously, it's open almost always to 2 different views at least. And in fact, 50% of our cases were unanimous. We're 5-4 in about 20%. And it's not always the same 5 and the same 4. That breaks down about 50-50 of those 5-4, 20%, maybe 10 or 12 or 15 a year. And so, of course, those are the ones that are in the newspaper. And so I said, well, to the newspaper people, when I talk to them, and I do, I talk, we have lunch occasionally, once a year usually, well, it's actually, there is no reason. Somebody asked me that in the press. It shows you what the relationship is with the press. He said, well, couldn't I interview you? I said, you can come in anytime you want. My door is open. They know that, the press. And I say, of course, it will be off the record, and then I will say nothing that I would mind if you print it on the record. And I said, surprisingly, everyone knows that in the press corps that surrounds us, and no one ever comes. There we are. Because that's not news, what I'm going to tell them. What is news are the results in the cases, particularly many, though not all, of the 5-4 and some of the others. That's a percentage. So his point that he wants me to get to, because I'm going on rather long, his point that he wants me to get to, David, is quite right. I've not heard in that conference room in 21 years, 9 of us around the table, I have not heard a voice raised in anger. I can still say that. I have not heard one judge say something really demeaning of another. I haven't seen that. Not even as a kind of joke or something. It doesn't happen. It's professional. I give my reasons. Others give theirs. We go around the table. We each have a book where we write down what the others say, because after all, if I didn't write that down and I had to write the opinion, I might not get that vote. and then we go back and forth, as long as that conversation is fruitful. It's professional. We are professionals. And I tell that to the law students and really underline it 5 times, because I want them to understand you do not have to get emotional when you are in an argument with a person on a matter of policy, a matter of law, a matter that does not concern yourself directly. It's too hard for us not to be emotional when something concerns ourselves or our families. But some other matter, yeah, do it. That's why you're going to law school, okay? You get emotional. I see some probably law students here, so I'll repeat what I say to them. You get too emotional, the other side will say, see, they must not have a very good argument. Now, we understand that. And that's what you wanted me to emphasize. That's the truth, and that's what I emphasize.
Do you spend much time talking to each other and sort of thinking through with one of your potential allies the arguments around the case, or is it mostly, do you do it mostly in isolation, reading the case, talking to your clerks?
It's mostly the latter, but not completely. The way it works is that, say, since I've said that we're limited to federal law questions, that's statutes in the Constitution, that's a tiny percentage of law. Almost all law in the United States is state law. Family law, business law, tort law, you name it, it's state. Education, it's state. I emphasize that. I told a group of Chinese visiting professors once that we were at Yale, and I said most of the law that affects families is made at Hartford. That's the capital of Connecticut, in case you don't know.
Yeah.
All right, so at dinner 3 days later, the head of the delegation, they said, "Do you have any questions?" And he said, "Yes, I have one." I said, "What?" He said, "Well, why is all law in the United States made at Harvard?" Anyway, there we are. But in any case, we will take maybe, because we have discretionary jurisdiction, maybe 70 to 80 cases a year out of, let's say, 8,000 or so requests. And we go through them. We have methods for going through them. We'll take those 70 or 80 because they're going to be the splits. And then we get briefs. And the briefs, stacks. I mean, the parties file briefs, and you can file a brief. You want to file a brief? File one. They're called amicus curiae briefs.
Do you have to read all
Yes,
this?
those on the certs, that is to say what we're going to take. 150 of those come in a week. And we will divide them among our law clerks, basically. There are probably 30 or so in the building for all the judges, and they'll take that 150 and work on about 5, and I'll get a stack like this of memos. And I'll go through that stack.
You have to read.
I'll read the stack of memos, but I can do it pretty quickly, and if you were to do it tomorrow and we tried to segregate out the possibilities, we'd come to almost the same conclusion. Because what I'm looking for is not whether the lower court was right or wrong, it's whether there's a division of opinion among the courts that have considered the question. Now, this is all quite technical, but you see what I'm doing. I'm now at the brief stage, and we get briefs like this. Of course I have to read those, and I divide them among the 4 law clerks, and they each read 3 sets, and I read 12 sets, or 10 to 12 for a typical two-week, but that is the job, and for a typical 2-week period. 10 cases, 12 cases, I'll read those sets of briefs. Now, if we're going to get 100 briefs, as we did in affirmative action, I start going like this after a while, because I'm going to see the repetition of the argument. And I can tell pretty quickly from the table of contents and so forth if it's simply telling me something I already have seen 15 times or not. But I will go through them. Probably I could read 2 sets in a day. That's typical. And my law clerks will read them more thoroughly. They'll write memos. I'll read the memos, I'll talk to them, we go into the oral argument, that's a half hour each side. We have Monday, Tuesday, Wednesday, Monday, Tuesday, Wednesday, 2 weeks, 2 weeks, 2 weeks. You get the idea? I know where I'm going to be probably next year on Thursday, the 14th of November, I will be. All right, but, and then we hear a half hour each side, we ask them questions. And it's very unpleasant for them. It's really tough arguing in our court, really tough. Because we only have half an hour, I wish we had more, but we should, for the lawyer. But we know the argument, or we think we do. And then we ask questions. And the lawyer starts answering. One judge is going like this, the other one, I mean, it's hard. But after that, then we have, on Thursday, we're thinking and trying to figure out where do we stand on this. On Friday, we're in the conference, and we're talking about the cases. And it's not definite. People are usually tentative. But they're getting more definite. And you'll listen. Now some of us, Nino Scalia thinks it rarely makes a difference what people say in conference because their minds are already made up. I can give him, and I do, example after example where it does make a difference. And we go around the table. Nobody speaks twice till everybody speaks once. It's a very good rule for us.
How long? How long do they speak?
On a typical case, I think a person probably talks 3 or 4 minutes, could be 5. Can be longer, it's tough. It could go on to 10, but that's rare. You can get your ideas across. So the key to it is they're really what you're thinking. Mm-hmm. They're really the points that are moving you, not some argument. This is what's really moving me. And absolutely frank. And as long as it's at that level, and it almost always is, then you go around, you write down in your book what the other person's saying, the essence of it, and then after everybody's spoken once, now, you might have some back and forth discussion. But that discussion lasts only as long as you're bringing up things that might really move the other person. I have a better argument than you, implicitly, ha, ha, ha. Forget it. Forget it. I'm listening to you and trying to see where you're coming from, and then trying to see if I have something to contribute to that. And if I do, by the way, I better be open to your contribution too. Because people sense immediately when you're being phony about something like that. So then I would say quite often there's a pretty, not always, but quite often there is a pretty good discussion. We'll advance the ball a little. People will have indicated where they're coming from and are they going to reverse or are they going to affirm, and what their reasons are. And on the basis of that, the Chief Justice, if he's in the majority, says who's going to write the opinion. He's not free. First, everybody writes one, and everybody writes two, and everybody writes three. And moreover, he has to assign the opinion, if he's in the majority, if there's a division of opinion, so that he gets a majority, 5 people. So if I take a 4-out position, it's not going to be assigned to me. You see? And I know how to get it assigned to me. I learned to my regret. I'm the last person to speak for 11 years. Suppose it breaks down 4-4. You know how I can be sure it's assigned to me? I just say, I don't know. I'm not decided. They have to assign it to me. You see? Figure that out and you'll understand how we do it. All right, so then I go back to the law clerk, and the law clerk will produce a memo like this, and I'll go read that, and I go read the briefs, and I'm back at my word processor. And there I am. Okay, and I give her my draft, and she thinks hers is better, but she doesn't say that. But then we go, and she writes, and I write, and back and forth, and there we are. We circulate it, and then I hope I get 5. And people send memos. That's where the discussion is that makes the biggest difference. The memo is sent. I like your opinion, and will join it, but I would like. Or I will join it, but I would like. I'm thinking of joining it, but. I probably, you see? And then A, B, C, D. And then there's modification and so forth. And then people might write dissents. And the dissent circulated. And it's sometimes, not too often, maybe twice in 3 years or so, the whole court flips. And you thought it was going to be A, and it's not A. That doesn't happen very often. But what happens very often is the tenor and the arguments in the opinion change. And I think those dissents, even when they don't become the majority, which is normal, serve a good function. And that's it. You've now got the process, and most people don't. So you're now like in the top 1/10 of 1 percentile of people who are interested in the functioning of the court. But that's why I say my job is reading and writing, and the interest of it, of course, is in the substance of what we're reading and writing about.
Do you find that if there's considered a conservative block of 4, that one person emerges as the intellectual leader among that group in the arguments, or is it pretty much scattered around, people pretty much on a level or equal playing field?
Well, you're looking at it as the outside informed observer.
Yeah.
And sometimes the press will try to do that.
Uh-huh.
I won't look at it that way. Mm-hmm. I mean, even if there's something there, I will resist it. Because my job is to decide the case. And so who is going to be the leader of this? I'm sorry, it's impossible totally to escape an ego. No human being can escape his own ego. That's certainly true. But you can try to minimize it. And the point is there is a difficult decision here. There's a difficult issue. And I want to get that right. And now, when I have my colleagues, I have got to be prepared to compromise. Mm-hmm. But up to what point? Up to what point? And there is no law or hornbook or predecessor or somebody else who told us up to what point. That's a personal decision, and you don't know if you've got that right either. But that's one of the... I was criticizing nonstop before I was appointed the court for the occasions which I hope have fallen, where you have 4 here, 1 here, nobody's on a 5 or not on an opinion. I say they don't want to know the Constitution according to me or according to Sandra O'Connor or according to Rehnquist or according to somebody else. People want to know what's the interpretation. Get 5 people, you know. And I said it's just ego. That's what it must be. So within 2 years, we have a big antitrust case involving the First Amendment. It's antitrust and First Amendment mixed up. And 4 people go one way, and they say Congress has the power to limit. Congress does not have the power to limit. Congress does not have the power to tell a cable system, you have to carry an over-the-air broadcaster. I mean, a technical issue, but important. Okay? 4 people say that because there's an antitrust problem. 4 people say there is no antitrust problem. They can do it. I think there is no antitrust problem, but they can do it anyway. Now, I taught antitrust, so I can't go along, but I agree with their result. So there we are, 4-4-1. Who's responsible? Me. Doing the very thing I've been criticizing everybody for doing. And what I'm trying to show you is that some of the most difficult parts here are really hidden in that they're hidden from me too. They're hidden as, when are you going to say, okay, that's all right. I don't think it's perfect. Nobody is. It's okay. And when are you going to say, no, I've got to write something separately? That's inside baseball. But that is, I'm trying to give you a flavor for the job. And that is what it is.
Wow, fascinating. Let's talk about your book and why you came to write it. It really, well, you explain the argument. It's and it's up here. He signed, I think, 146 copies already, or so. But afterward, there'll be an opportunity for you to come forward if you haven't done so already.
Yeah, you can.
But you should know a little bit about the thrust, because it's a really interesting and provocative new world we find ourselves in. The court finds itself in.
Yeah, why write this? What is it? Why did I write? Stop me before I strike again. But the point is this: that I did notice over a period of 20 years that more and more of the cases, maybe now 15%, 20%, would require for us to decide them correctly, us to know something about what happens outside the boundaries of the United States. Now, it takes a lot of forms, but it's growing like that. And the reason I tried to pull those together and to give examples, it's a kind of report from the front. I said, well, why do that? Because I think I felt and thought others might feel a little bit like the example I use is in the Charterhouse of Parma. If you haven't read it, it's a great novel. And there in the battlefield at Waterloo, there's the hero, Fabrice Del Dongo, wandering around there, bullets flying, and there's horses running back and forth and a lot of smoke, and Napoleon is over here and over there, and Fabrice Del Dongo thinks to himself, gee, something really important is happening here, and I just wish I knew what it was. Well, when I read these words, interdependence, globalization, I have somewhat the same feeling. And I thought maybe other people do. So let me try to give you a report in the form of absolutely concrete examples to show you what this word interdependence means concretely for at least one institution, namely the United States Supreme Court. So therefore, I've tried to stimulate thought on the part of others by giving them concrete things to think about in the form of the problem of how do we deal and should we deal with cases that arise out of commerce, which is across the world, cases that arise in the human rights area. I can give you some very interesting examples of torture that takes place in Paraguay, cases involving the age-old problem of security on the one hand, the needs of security, and the needs of human rights, which, I mean, security is a matter for the president and Congress. But wait, human rights is a matter for the courts. 10, called the Bill of Rights. What happens when in the name of security, the president says we have to limit ordinary human rights principles? We had 4 cases out of Guantanamo. And the key to those cases, I think, is in Sandra O'Connor's words. The detainee won each of those cases. Not the most popular person in the United States, bin Laden's chauffeur won one of them. But what she said was the Constitution does not write the president a blank check. Well, that's a good point. I joined that. But of course, immediately you all think, and everybody does think, fine, it doesn't write it a blank check. What kind of check does it write? You see? And those cases and others like them will come up. And that question will have to be answered gradually. Try to answer it without knowing something about the nature of the international security problem. Try to answer it without knowing what other countries in similar situations do, which is at least helpful. And very often, we must. I mean, I give those as examples, but I want people to see in that area how the law has changed. I mean, if you went back to the Civil War, you would find people who really believe in Cicero. And I believe in Cicero, but I don't believe in this dictum of Cicero. He said, in time of war, the laws fall silent. And they did for many years in the United States. You see, that's why we know the case in the law schools. I mean, 70,000 Americans of Japanese origin were detained in camps, prison camps. In World War II, they'd done nothing wrong. They were not a risk. And they were put into camps, and the Supreme Court said that was all right. I think it was following Cicero. You see, somebody has to run this war. Roosevelt or us? We can't, so he can, so put them in camps. Now, it doesn't work. All right? You admit that doesn't work? You're then into Guantanamo, where we are trying to do some of the balancing anyway. We're trying to do some of the balancing or rebalancing or say the president can't go too far. Can you do that without knowing the nature of what's happening abroad? No, I think you can't. And that's a real problem that is incredibly serious. And the commercial problems. You want an example?
Please.
Or should I give Phil Artiga?
I think Paraguay is more interesting.
All right, Paraguay is more interesting. Take my word for it. There are lots of commercial problems. Paraguay. Paraguay. Phil Artiga comes to New York from Paraguay in the 70s, the mid-70s. And there in New York, she sees and meets the man also from Paraguay who tortured her brother to death. Right? In Paraguay. She also finds an old law passed in the 1790s, probably to protect victims of pirates. And it says an alien can bring a lawsuit in an American court and recover damages for injury caused by a violation of the law of nations. That's called the Alien Tort Statute. She says, see, that's what he did. And she recovers. She goes back to Paraguay. And she says, I came to the United States just wanting to look that torturer in the eye. And I came away with so much more. All right, now, other people followed her example. Lots of suits were brought and are brought. And now we have a few legal problems. Well, who are today's torturers? I mean, who are today's pirates? Who are the pirates of today? Torturers, yes. Who else? Mm-hmm. And what happens if someone brings a lawsuit and trying to protect victims of apartheid, and South Africa files a brief, which they did, and said, we don't want American judges dealing with apartheid, with whatever good intentions they may have, because we have our own system called truth and reconciliation. So you stay out of it. What are we supposed to do there? What are we supposed to do? How do we interpret the statute? And how do we interpret it in a way that will harmonize with other states' or countries' systems which are aiming at somewhat similar things? I mean, you want this to work out in harmony with other related statutes across the world and not to be at cross purposes. If I want to summarize that kind of consideration, I say you don't want everybody in the world trying to sue Henry Kissinger. You see, that's a problem. So you need an interpretation that is going to work in harmony with others and not at cross purposes. And there is no Supreme Court of the world to reconcile what can be the conflicts. And so the only way to do it is if the separate courts try to think about the implications of universalizing the principles that they're writing about insofar as they might lead to real chaos among the nations. There's a principle for that. It's called comedy. On the European continent, I think they call the same thing courtesy, which at least has the virtue of being understandable. But comedy, no one knows exactly what it is, and so that might be an advantage. I don't know. But you see the point. Now, those questions come up with more and more frequency. And of course, the commercial area is a great area to find questions like that. What happens in Ecuador when a vitamin distributor wants to sue a vitamin manufacturer from Holland who's part of a cartel that raised prices, and he brings his lawsuit in New York. Why New York? Well, of course, one explanation could be that they raised the price so high, he's simply too weak because he has no vitamins and can't get to Europe. That's one explanation. Another possible explanation is that we give treble damages and attorney's fees. That's a possible explanation. And the question is, can he do it? And we have to interpret the statutes, which don't really say very clearly, in a way that will work out, because we must take into account the fact that Europe has its cartel authority, the anti-cartel authority, and they file briefs, as does France, as does Germany, as does Japan. And that's the world. There's a similar problem with securities law, similar problems with copyright law, similar problems all over the place. And I just want people to see the kinds of problems that we have when you start asking the question of what do we decide, what is the law doing in our court where it involves a need to look beyond our own shores. Now, how many, and I had to find this out, I looked it up, and Professor Cassese had his assistants looking everywhere, they got an answer. How many organizations do you think there are created by treaty or by executive agreement or in some other way where they're little bureaucracies that actually make rules that bind citizens, businesses of more than one nation? The little bureaucracies over here, like the they're in Ball deciding banking regulations. Who? Well, banks, and also our securities people, the administrators at the SEC. And then they come back and they promulgate them so you can comment, but the real decision could have been made in Ball. And hey, how many organizations like that do you think there are? 50? Raise your hand if you think there are more than 300. More than 1,000? You're getting warmer. 2,000, says Cassese. 2,000. And we've joined several hundred of them. And what's the status of those? I mean, there's the Bluefin Whale Commission. There's the United Nations. There's the International Olive Oil Council. You know, there are a lot of them.
And when disputes arise within those organizations, they can come into American courts?
Good question. There are cases that do. There are cases that have. And if you say in these cases, well, there are rules, that's just it, Congress, ICON. ICON, everybody knows, whether they know the name ICON or not, it's affected every person in this room. ICON is the organization which is a kind of corporation from Los Angeles that sets all the rules for the internet. A lot of them. Well, what's the status of what you say? This is the world we're in. You know the world. And what I want to do is show you what that world means as it turns up in cases that are likely to be there or have been there in our court, where you have to get answers. And with all those organizations, I'll give you an example. If you were talking in a political forum, I bet you'd hear people say, of course you have to delegate all this authority. Well, of course you can't delegate authority to these bureaucrats over in Ball. It's Congress that's supposed to make the law. I say, really? If you can't, how are we going to participate in solving the problems of environment, security, health, commerce that are arising every day of the week? Okay, well, they can do whatever they want, Congress. Oh, really? We can delegate every power to them? What happened to Article 1 of the Constitution? Now you say, well, I'm just being theoretical professor-like. Really? The German Supreme Court, the Austrian Supreme Court, the Italian Supreme Court has faced a question virtually identical to what I just described in trying to work out the extent to which their nations can delegate rulemaking, i.e. lawmaking power, to the EU. And they've struggled with this kind of problem. So we're not the only ones. We haven't had it yet. We've touched on it in a couple of cases. We've touched on it. But this is the world I want to describe that I think you're going into, younger ones. And there we are.
Let's go to the hot button issue within this large complex, because there is this question of sovereignty. And the Europeans have been much more willing to give up sovereignty in order to join the EU and the Eurozone and that sort of thing. And the United States, Americans have always been very proud, protective, insistent on American exceptionalism. We don't bow to the sovereignty of anybody else. And so there's this hot issue that you've been deeply involved with on the question of the death penalty. And you've just issued a very strong dissent we'll come to in a moment. But the question is, how do you know, the Eighth Amendment, as you well know, prohibits cruel and unusual punishment. And the question then arises in the death penalty area, what is cruel and unusual, and how do you judge that? And what standards or to what should you look to determine what is cruel and unusual? Where do you find your guidance? And your argument is, in part, you ought to be looking at what other nations are doing, other civilized nations are doing, because they're facing some of the same issues. But you can say this much more eloquently.
No, well, in the case in which we can go back to, but I mean, I have 2 pages, but only 2 out of about 40 some odd pages where I wrote an opinion and gave a lot of reasons and studies and so forth why the court should re-examine. I said that I thought it was time to re-examine the constitutionality of the death penalty. But I did put those 2 pages in, but I think, in fact, that word unusual, does it mean unusual in the United States or does it mean unusual in the world? And you can look all you want into the words of Madison and Jefferson and everybody else, and I don't think you're going to find the answer to that question. And the person with like many other cases, the best wisdom, which is so truthful, was Justice Jackson, who said, when you look for cases that tell you, and this it's like that, the president's power, foreign affairs, what are the limitations on the president's power? Go back to see what the founders thought. He says that's like asking Pharaoh, that's asking Joseph interpret the dreams of Pharaoh. Said, well, you don't find the answer there to this one, a lot of others. So that, I think, is what stimulated a lot on the political, in the political world of feeling, don't start citing foreign cases. They don't, negative, why? Well, my own belief is that it's sort of a kind of what Joanna, in her profession of psychologist, or your wife would call displacement. They don't like the result in the death penalty cases, the people who say that, or in the gay rights cases where people have cited foreign things, and so they blame foreign law, which has nothing to do with it, really. But that's what's going on. Now, I've talked to enough people who think that, and I put in the book, for a reason, I'm trying to convince them in a sense. And they're not easy to convince. I'd say, look, I understand why I don't convince you with my excellent arguments. I don't convince you because what you're really worried about is you're worried about protecting basic American values. And you fear that if we start citing foreign judges who have views that you, Breyer, might agree with, that's going to be bad. You're going to give up our basic American values. So here I want to say, look, I'll accept that. I agree with you, and perhaps just as strongly, that it couldn't be more important for us as a nation, democracy, human rights, rule of law, and so forth. Now, you read my examples, please. And now you tell me if the best way in the world that I describe to preserve our American values is the better way to pay no attention to what goes on abroad, not to read their decisions, not to find out, or is the better way to participate and find out and think about what they're saying? Because after all, the world will go on without us. And if we don't participate in solving these great problems, or at least reducing them, they'll try to on their own, and we might like the result less. So, I mean, that's the argument I'm dealing with there. But there is something, you see, under the word sovereignty, which it's a little 4th of July speech, but it's truthful, I think. And that is that we have more at stake. And I don't usually say exceptionalism. I don't particularly want to use that word. But we do, in a sense, have more at stake than many in trying to get this complicated system of laws and so forth working towards the solution of these terrible problems of environment and security and business and so forth. Why do I say we have more at stake? And when I'm asked that, I say, because look, and I see this every day in the court, to tie it back to the beginning of how the court works. What is it I see? Look, I say, we are not all descendants, like the French, of Pepin the Short. And we are not descendants, even like the English, of King Arthur. We are a very motley, diverse group of people. And what holds us together as a nation, part of what holds us together, is the totally non-tribal fact that we have this system embodied in this document. And that's why people do get emotional about it, even when they don't know what it says. You know, it isn't that long. I have to work with it. You can read it. But they do. And I see in front of me every day, people of every race, every religion, every conceivable point of view, and there they are, having decided to resolve their differences in courts of law. And I think, one, that's a fabulous thing and a tremendous asset for America. That's obvious. And it's also part of who we are, just like King Arthur is part for the Brits. and there we are. So we have a strong stake in seeing that this law, this complicated system, this resolution of disputes through courts and judges who have no special insight into anything, but it's a way of solving problems. And to see that that continues. That's called the rule of law. As I say, it's a little 4th of July speech, but still, I think it's absolutely truthful. And I think it has a tremendous implication for the way we proceed to resolve what I'd call these problems that I can put under the rubric interdependence.
Let me ask one last question, and we'll invite you, if you'd like to ask questions, to come to the microphone. We started a few minutes late. We're going to run a few minutes late. A question that's troubling many Americans is that as children we were taught that Lady Justice is blindfolded and impartial in deciding what the law is, and therefore the law deserves a lot of respect. But what we see increasingly on the court is that if a person has been appointed by a Republican president, they vote one way, and if they've been appointed by a Democratic president, they vote the other way. And it seems less like something that's impartial than a power contest. Who has the most power to name the nominees, and that will determine what the law is. How much of a problem is, how do we deal with it?
I think when I think of the problems for the court, I would put it this way. I think our biggest problem, related to what you say, is that people think we're junior varsity politicians. That is, and when you get to an audience, particularly of the younger students and so forth, you'll probe not too deeply and you'll see that's what they think. What do I say to them? You're too cynical. No, they don't. That gets me nowhere. Look, I did work for Senator Kennedy. I worked in the Senate. And politics to me means where are the votes? Are you Democrat, Republican? Are you popular? Is this popular, not popular? Will it get me votes or not get me votes? I say, I don't see that in the court. I really don't. Haven't seen it. You say, what about Bush v. Gore? I say, I need an hour. But if I had that hour, I think I could move you even on that one. And so that, oh no, they say, well, we're not really thinking politics in that sense. We're thinking ideology. So I say, oh, you mean, am I an Adam Smith free enterpriser? Or am I a Maoist troublemaker or whatever? I say, if I'm writing an opinion, and I think that's what's moving me, I know I'm doing the wrong thing. And I'll try to avoid being moved by that kind of consideration. Well, there is a third thing. And the third thing is this: I am who I am. I was born in San Francisco. I was raised there. I grew up in the 1950s and I went to Stanford, and I went to public high school in San Francisco, and I've lived a lot of my life here in Cambridge, Mass, and there we are. And that after a certain time in our lives, we have views about things, not views that are detailed necessarily, but certain outlook about, well, if you're a lawyer, what's the law about? Why is it there? I mean, what's the Constitution? Well, what's it about? I mean, how does it relate to people? What's the country like in ways that are relevant to interpreting this document? And you can't jump out of your own skin. And you're not going to change on that by the time you reach a certain age. And it isn't surprising that people have different sort of basic philosophies there. And do they come into play? Sometimes. Sometimes. Probably a lot less than people think. But sometimes, with these big open questions, the freedom of speech, liberty in the 14th Amendment, of course they do. And I don't necessarily think that was a bad thing. My first 2 years there, I'd come into, people in Cambridge disagree with each other, and in San Francisco too, but I'd never seen disagreement that I found in Washington, even on the court. That's disagreement. So I thought, why don't they all think like me, who's always right? You see, no. Then after a while, I think I reached a somewhat more, maybe better outlook, which is this is a big country. There are 315 million people, and they have every view under the sun. And it isn't such a terrible thing. It isn't such a terrible thing that you have people appointed probably by different presidents. Not necessarily. Bush v. Gore, you had 5-4, and 2 of the 4 were appointed by Republican presidents.
Correct. But Citizens United.
Citizens United, I don't know, did it work out 5 in the 4 thing? Was it 5-4? Were the 4 appointed? Citizens
United, but I think it was 5 Republicans.
And anyway, you see the point. That's possible. Yeah. Presidents will try to appoint people who share a very broad philosophical outlook. Call it a very basic jurisprudential thing. Teddy Roosevelt appointed Oliver Wendell Holmes. Within 3 weeks or 3 months, Holmes came out the wrong way in an antitrust case, and Roosevelt was so angry, he said, I could carve a judge with more backbone out of a banana. They're not going to get it right, if they think they're going to get a judge who's going to agree with them all the time. Mm-hmm. They might, but will sometimes not be right, if they're looking for this kind of basic philosophical thing. And they won't always be right there either. But I think that explains why you do get differences in some of these major cases. All right, are these judges then just being politicians? I don't see that. I mean, they think that's how it goes, I don't think it does. And so I think it goes this way, and they think it goes that way, and we're both talking law. And we're both talking constitutional law. And we're maybe coming from somewhat different places. But that isn't politics. Yeah. And that doesn't stop the judges in a really tough case from having to sit there. And maybe sit there in the night, and maybe not, how am I going to do this? Am I honest with the record? Am I doing what I think? And you say, well, hey, the New York Times will write a decision saying how brave my dissent is. I say, I'd be brave if I did the opposite of what they want. That's not bravery. You can't look for newspaper editorials. You can't look for, that's just not it. And go into some other profession. So am I giving you a picture? Mm-hmm. And it's that picture which is really what I see. And I don't know how to communicate that so that people who read the newspaper will actually understand that we at least don't think we're junior league politicians. And it's important that they understand that. Hamilton put this group in charge of, Hamilton believed that they would say that laws of Congress were sometimes unconstitutional. He thought that because he asked himself, and read Federalist 56, it's great. He explains it. He says, look, I've written this beautiful document. Well, If people can just run around the boundaries that it traces, and that's all it does, it traces boundaries. But if they can just ignore them, put it in a museum, hang it up in the Smithsonian. I mean, actually, the Smithsonian wasn't there then, but nonetheless, you get the point. So he said, now who? Who should have the word here that whether it goes too far, whether an official has gone too far? The president? He's too powerful already. Believe me, if he has the power to say everything he does is right, he'll just do what he wants, say it's right. No, we don't want to risk that. Congress. Congress? Well, they're elected. Why not them? And many countries have done it that way. And he says, well, you know, Congress, they're expert. They know popularity. Popularity, believe me, they know it. And if they didn't know it, they wouldn't be where they were. And, but this document is written for the least popular person, having exactly the same rights as the most popular person. So I'm nervous about Congress, but here we have these judges up here. They're gray. Nobody knows who they are. Fabulous. And they don't have the power of the purse, and they don't have the power of the sword. Ideal. We'll give them the authority, because they can't think of anybody else. And it's pretty, read Federalist 56, and you'll see I've only exaggerated a little. And so there we are. And that stood pretty well. The court's made some fairly major mistakes in its history. And you sit there hoping you won't make another. I mean, Dred Scott is not a marvel. Terrible. And Plessy and Ferguson and a lot of others you can name that really have been big mistakes. But the system gradually has worked to the extent that people will follow a decision they don't like, even if it might be wrong. And that's called the rule of law. And it's that history that I try to explain when a woman from Ghana, who's the president of their court, came in and said, why in heaven's name do people do what you say in the United States? Because she wants to try to make her constitution a little bit more protective of human rights and democracy. Why do they do it here? And I say, I can't give you an answer, you know, that'll take 2 minutes. I'd have to give you a long history. And it is that history. It includes a civil war. It includes slavery. It includes 80 years of racial segregation. It includes many, many years of trying to dig our way out of that. To this day, you know, and all that is part of us. All right, so that's a long answer, but it brings us around, why do I write these books? I'd like people to see it, that's why.
I just want to ask you, our Constitution is largely one of negative rights, constraining the government from acting against us in various ways. But lots of foreign constitutions include positive rights to things like healthcare and housing and a good environment. So would you like to see more of those things in the American Constitution?
Well, I can't change the American Constitution by rewriting it. And what's interesting, where they have these rights, of course, they have added problems. Their problem is you can say everybody has a right to a house, and then fine, where are you going to get the money to build the house? And everybody has a right to this or that, which is fine, but where do you get the money to pay for it? How do judges do that? They just have an office and a computer, as I say, and how do they do it? Well, the countries that have that have found ways of dealing with this problem. And how sad is that? You know, I won't go into the ways, but they do have ways of dealing with it. So it's not an impossible thing to have in a constitution, but we don't.
Right. Thank you.
Thank you for coming. My name is Randall. Chief Justice Roberts was quoted in June saying something to the effect of, because certain people can't win at the ballot box or win certain votes in Congress, that they bring cases to the Supreme Court. Do you agree with that notion, and is it going to get worse or possibly get better?
Do I believe that people do bring things to the court? Would they prefer to win it at the ballot box? That's true. But that isn't automatically an answer as to how the court will turn out. Because after all, the job of this document, in part, is to give certain rights, i.e. the basic rights that it guarantees, to people who don't have the power to win at the ballot box, because they're unpopular, because they're a minority, and because they're being hurt in a way that this Constitution protects against. It doesn't just decree what's good or bad. It doesn't do that. It draws boundaries that are very broad, within which the ballot box holds sway, as it should. And one of the harder things to do is to decide, we're at the boundary, is abortion in or out? Which way? Good arguments both ways, perhaps. You see? And so there we are. I say it's a good statement, doesn't answer the question.
Thank you. Thank you.
Good evening, Justice Breyer. You spent a while talking about the problem of the large number of rulemaking bodies, but what scares me is the opposite side of the spectrum, where the scale and scope of rulemaking by treaty become huge for a very small body, like the Trans-Pacific Trade Partnership. What can and what should we do about this problem of rulemaking by treaty?
Well,
at large
is it
scale?
a problem or isn't it a problem? I don't know. What we have now, and from what I'm not an expert on this, but I know people take different views of the matter. And you had to get a treaty, you have to have the president, and he has to agree and sign it. And then you have to get 2/3, don't you, of the Senate of the United States? And that isn't so easy. So we have maybe, I don't know, 1/3 of 34 senators could block this treaty. And if it's something of great importance and people are interested in it, they'll try to inform themselves and figure out. That's not the whole law in the area, but that's where you start.
Hi, my name is Dr. James Baker, and I'm a hospice physician here in Boston. And as such, all of my patients are terminally ill. And when patients near the end of life and are suffering with no means to manage that any further, do you think that the Constitution would grant them the right to request an end to their life, and for us as physicians to respect that request and provide them a means?
All I can say by way of answer, because maybe that'll come up, you see, and I can't, for a variety of reasons, I can't say how I would vote were it to come up. But I can say how we did vote. And that case did come up, but it came up in the context of 2 states which did criminalize assisted suicide. And the question was, does the Constitution give you a right to assisted suicide? The answer the court said was tempered. That is to say, it said, no, we're not going to say now that it does. And one reason, and Justice Souter wrote, which was, I thought, a good opinion, and he was give the legislatures a chance here. You see, we have Oregon, we have California. You just heard the last question. And there's part of not going too quickly. There's part of what Tocqueville said about the United States. He says when he comes to the United States, he just sees nothing but people arguing. And he ends up thinking that's not so bad. They argue about things like you brought up. They argue about it in states. They argue about it in cities. They argue about it in journals. They argue about it in bar associations. They argue about it everywhere under the sun. And they try things out. They try things like we're seeing tried out. And they have rules, and they have regs, and then they change them, and we're best, I think, as a court, when we come into a new area, let's call it privacy. Things changing rapidly. When we come in last, because we're not really experts on everything, if anything, and let's see what other institutions do, and then we're there to say when they went too far. What Souter and O'Connor and I wrote in that is that before us, each of these states has a system so that people don't have to die in pain. It's called the law of double effect, which is not a law. It is a kind of philosophical principle, and you understand it.
Yes, sir.
And that was true in all of those states, and we said the situation might be different if it was a question of dying in pain. That's where we were.
Thank you, Justice Breyer.
Hi, my name is Sophie. When did you first decide you wanted to be a judge?
Good question. Now, when I was your age, I wanted to be a baseball player, but I knew that was hopeless. And I think probably being a judge, it sort of comes as a surprise because somebody else has to decide that you ought to be a judge, and then they ask you if you're willing to be, and usually sometimes people don't want to be, sometimes they do. So I'd say I thought about this most when I was probably in my, seems awfully old to you, but I was in my early 40s. And the opportunity came up, and I thought it would be a very worthwhile thing to do. And I think whether I'd been appointed to this job or not, I think it has been.
Thank you.
Thank you, Justice Breyer. My name is Joshua. I'm a Singaporean LLM student at the law school. And so I've read this book with quite a lot of fascination. You say in the book, Justice Breyer, that, quote, I would favor adding the judge-made concept of proportionality as a guide in deciding First Amendment cases, unquote. As a current student of First Amendment law, I find this very, very commendable. And I'd just like to seek your views. Could you speak more to why you think this would complement the current category-based system?
Now, this is sort of inside baseball among First Amendment lawyers. and so I have to be careful not to go on too long. So because I do write about it. And I say I think it's an example, growing out of meeting some of the other judges and learning how people do things in Europe and other places. It's an example of, I think, we were already doing it. It's like Moliere and speaking prose. I've done it all my life, and I didn't know it. I mean, that's so I say, we might take some of what they do in order to clarify what we're already doing under the different word, balancing. And so I try to explain in there partly how to do that.
Thank you.
Thank you. We'll be able to take nobody else on. We'll try to get through as much of this line as we can, but we'll end there at the end if we do get there.
Hi. I was wondering if you could talk for a moment about your internal thought process, how you make the decisions you make in the tough cases.
I think that the process, this is something people have asked me before, so I'm not, and it's a very good question, but I suspect, and here I don't know, that it's quite similar to the way people decide things in any profession, or maybe in business as well, how you would decide things in a matter that's of some importance and it doesn't affect you. All right, I open the brief, blue brief, that's the petitioner. I read the question. Yeah, I think I know the answer. She says, are you open-minded? I say, this is open-minded. I read the brief. Hey, I had the answer. Then I read the other brief. Oh! You see, we read through these briefs and you sort of think it's like an old joke. The judge says to the plaintiff's lawyer, you're right, you're absolutely right. Then he hears the defense lawyer, you're right, you're absolutely right. Then the plaintiff's lawyer gets up and says, Judge, you said I was absolutely right. Then you say he's absolutely right. We can't both be absolutely right. The judge says, you're right, you're absolutely right. And it's a lot more like that than you think. So then you're at oral argument, you see, and law clerks all think that makes no difference. It does, actually, to how you see the case. And you're listening, and you sort of, yeah, I see what it is. And then your mind is you're sort of gradually coming in on something. And then on that Thursday, you get a tentative position. Now it's more definite. And you get into the conference, and by the time you walk out of conference, you're pretty definite. My God, that happened to me this morning. We had cases this week, I have to tell you. You cannot decide them. And then you have to decide, so that's the job. And so you get in, finally you get through the discussion, you think, all right, I see this side there are technical cases. I said, this side is just a little bit better. So there we are. I've now made up my mind. Not quite. I haven't read the opinion. Then I read the opinions or I write it, and now I've made up my mind, vote, it's over. Okay, there we are. Boy, that was tough. Day one after. God, that was tough. I mean, day two, it was really tough. I'm glad I chose the right side. Day three, sure was the right side. Week 4, how did I even think the other side was right? All right, that's the human mind at work. And I think it's similar in whatever decision-making capacity you are. Open-mindedness does not mean you have no view. Open-mindedness means you are ready to be persuaded. And that's what I think it comes down to.
That's interesting.
So we see these cases where popular opinion seems to have a really big influence on the way that the ruling is decided. So maybe the classic example is Brown v. Board of Education, right, where a change in popular opinion seemed to have a huge influence on the ruling. I'm curious, to what degree do you think popular opinion can influence interpretation of the Constitution, and what are some of the constraints on that?
I'm tempted to say, which I think is the truthful answer, 0. But then you say, well, what are you talking about with Brown versus Board? Everybody said they waited an awfully long time. Now I'll say something that will undermine my zero. You see, because go back and if you ever have the chance, read a Holmes opinion about the 15th Amendment, which says you cannot discriminate on the basis of race in respect to voting, okay? So a case came up in the Supreme Court, where of course that was what was going on in the South, and people knew it. And Holmes is asked there, he writes the opinion. And what he reads, if you read that opinion carefully, which decided against the plaintiff, who was saying, I've been discriminated against, he said, it just wouldn't do any good because they wouldn't do it. And there's no doubt they wouldn't at the time he was writing. So call that, with the Brown case, which is indeed special, an institutional consideration. Will people follow what the court said? And you may not know this, but I do because I wrote about it once, is that the Cherokee Indians own northern Georgia. The court said it's theirs. And Jackson, who was president then, said John Marshall made his decision, now let him enforce it. And he sent troops, and those troops were not sent to enforce the decision. They kicked the Cherokees out of Georgia and sent them along the path of tears to Oklahoma, where they live to this day. Now, you see how I'm distinguishing between listening to public opinion and that institutional consideration? Okay. And that institutional consideration may come up once in a decade, but it sure was there with Brown.
Interesting.
And they were glad they reached Brown finally.
Interesting.
And Frank, well, it's a long story.
Yeah. Thank you.
Good evening, Justice Breyer. My question is, you spoke earlier this evening about the balance between security and rights or freedom. I believe it was last year there was a case, and the name escapes me, of course. I believe Roberts wrote the opinion where it said that police incident to arrest cannot search the contents of a cell phone. Now, without a warrant. Without a warrant. And I just juxtapose that against the what we found out when Ed Snowden blew the whistle about programs like X-Keyscore, where supposedly the United States government is literally collecting data on every...
You want to know what we will do about Snowden? And the answer is I can't tell you. The reason that I can't tell you, and it does let me say this, which is true, is not because I don't know, though I don't. It's because the reason people say judges have to hesitate and probably not comment on things that might come before them is simply that. What I might say in a casual conversation, in respect to an issue that might come before us, then might turn out to be not what I think after a process. And that's what we do. We go through a decision-making process that involves reading the memos, reading those briefs, thinking about it, the process that I described. And after you go through that process, a significant number of times, things turn out to be not what you thought they would be if you were just talking to people casually. And that's why.
Thank you very much.
Hi, Justice Breyer. My name is Nora, and I'm a fresh year in college. I just want to say what an honor it is to meet you. I'm very happy. Basically, what my question for you is, as a judge and as a Supreme Justice in the land that's considered one of the highest countries in all the world, how do you make such profound decisions on so many issues such as gay rights and other things that not only affects the United States domestically, but also internationally in other countries as well?
You mean, what is it like? And two things that when I was appointed, or the year before I was appointed, when I met the president, President Clinton appointed me. Mm-hmm. And he made a point, he said, after the applause dies away, you're left with the job. And so you'd better like it.
Right.
And that's true. So what people do, I think all of us there, and probably every judge who's been there, is the job is one to which you have to give what you have. Mm-hmm. And that's true whether this is a very big case involving the issues you raised, or whether it concerns where a comma belongs and what that comma means in the Internal Revenue Code. And I'll tell you, even that case, my brother is a district court judge, a trial judge, his cases involve typically one person or two. It's just as important to them. And so this is a job which you take very seriously. It doesn't mean you have to go around with a serious expression all the time, but you do take it seriously. You do the job, you read, you think, you talk to your colleagues and your clerks, and then you try to decide it as best you can. And for 3 years, I'll tell you, or maybe sometimes 5, you go around in a panic, how am I ever going to do this? And then after 5 years or so, you think, well, I'm going to do it the way I do it. I'll do it the best I can. Right. And there we are. And you relax a little bit.
Thank
there
you
we
so
are.
much.
Thank you, Justice Breyer. My name is Ishan Hashmi. I'm an LLM student at Harvard Law School. You spoke a lot about your law clerks. In general, what kind of discourse do you have with your law clerks? And more specifically, is there any influence that a law clerk may have on judicial thinking?
Oh, yes. They're the ones who look things up. And moreover, I read what they write. And they're good, they're wonderful, they're good company, and they're wonderful. I love my law clerks, all judges do. And they're there for a year, and I talk things out. I like talking things. Some people, we were talking about Justice Thomas, he likes to think things through in his mind. Less talky. I was a professor. I'm more talky. And so I'll talk to my clerks, and I believe that I make my own decisions.
Thank you.
Good evening, Justice Breyer. You mentioned the United States' high position in arbitrary, in trying criminal courts and international criminal courts and human rights and war crimes. But the United States has failed to sign the Statute of Rome, which would put the United States under the jurisdiction of the International Criminal Court. Do you not find any contradictions in the fact that the United States determines these cases but doesn't put itself under the jurisdiction that many other nations do?
You mean, why didn't we join the International Criminal Court? Well, that wasn't my responsibility. What's interesting to me in reading about it is France had the same problem. I mean, there were a lot of people, and particularly the military said that they're worried about this. What they're afraid of is that they were afraid in France that the criminal prosecutors in the International Criminal Court would find visible things that the Army did. They'd all be prosecuting us, and that wouldn't be fair to the military. And they got the same argument in France exactly, which joined it, but they joined it on a provisional basis. And said, let's see how it works. And then after a while, they became convinced that it would work all right. So there are models, and maybe eventually we will, and maybe we won't, but that's not going to be my decision.
Thank you, sir.
All right, last question.
Good evening, Justice Breyer. My name is Vibhusha Karki. My question is related to international stuff, since we were talking about how the world is internationally connected. Recently, Nepal passed its constitution after changing itself from a monarchy to a republic country. And after passing the constitution, India has imposed sanctions against Nepal because it does not agree with Nepal's constitutions. And the sanction has resulted into people not having access to fuel for cooking or doing everyday things they do in their life. And the sanction has been for a month now. I was wondering, what would your suggestion be to the justices of Nepal?
I can't make a suggestion. I did. We were in my sabbatical, 1975, 6. We were in Nepal. Beautiful.
Thank you.
And we had a trek through the mountains to Jongson, was it? You could overlook.
Yes, it's Jongson.
And we could see Annapurna. Mm-hmm. Beautiful place.
Thank you. I'm glad you had a good experience.
I know you want a concrete suggestion. And what can I say? I don't know the concrete answer to that. Bring them there and let them see this beautiful place. It'll put them in a better mood. And I have nothing really that I can add. I don't know is the answer to that. But I'm glad you're here and have the chance to study here.
Thank you.
Quick show of hands. How many leave here tonight reassured about our court?
Oh.
Thank you, Justice Breyer.
She can follow her conscience. She just can't be the clerk of that county. That's fine. But that's the way the system works. And if you actually read Scalia's decision in the case, the Peyote Indian case that led to the original RFRA in Congress, he basically said that government officials and governments can't be in the business of allowing these kinds of distinctions, particularly when they impact other people. So I don't think that the argument for her really has any weight at all. I think the harder argument is kind of the Hobby Lobby version.